All right, welcome to The Explainer. Today, we're going to tackle a legal concept that sounds simple but is actually pretty tricky and super important: the doctrine of ripeness.
So, here's what we've got on tap. We'll kick things off with what ripeness even is, then look at where it comes from in the Constitution. After that, we'll get into the big test courts use, a major debate happening right now, and finally, what the future might hold for this whole idea.
All right, first things first, what is ripeness? When is a lawsuit actually ready for a court to hear?
Okay, let me ask you this. Say a new law gets passed, and you're pretty sure it's going to hurt your business or your rights, but it hasn't happened yet. Can you just run to court and sue right away? Well, the answer to that question, it all comes down to ripeness. Basically, you can think of ripeness as the court system's bouncer. It stands at the door and tells some lawsuits, whoa, hold on, you're not ready to come in yet. It's all about making sure courts are dealing with real, concrete problems, not just a bunch of what-ifs that might never even happen.
Right, and the whole point is to stop courts from jumping the gun. They want to avoid getting tangled up in disputes that are still just fuzzy possibilities. The injury has to be more than just a guess, otherwise the court's just wasting its time on hypotheticals. So you might be wondering, where did this idea even come from? Is it just a rule judges made up to make life easier? Nope. It actually goes all the way back to the U.S. Constitution itself.
And here it is, Article 3 of the Constitution. It says the court's power only extends to cases and controversies. That little phrase is a huge deal. It means federal courts can't just issue opinions on what they think the law should be. They have to wait for a real live dispute between actual people. Now, this is a really helpful way to think about it. Ripeness is part of a family of rules called justiciability. Basically, rules about what courts can and can't hear. It's easy to mix it up with its cousin, standing, but think of it this way. Standing asks, do you have the right ticket to get into the courthouse? Ripeness asks, is the show about to start, or did you show up way too early? One is about who can sue, the other is about when they can sue. Okay, so we know why the rule exists, but how do courts actually figure out if a case is ripe or not? Well, for that, we have to look at a huge Supreme Court case. Back in 1967, a case called Abbott Laboratories versus Gardner came along and basically wrote the rule book for ripeness that we still use today. Justice Harlan laid it all out. He said the point is twofold. First, to keep courts from getting dragged into abstract arguments about government policy, and second, to stop lawsuits from messing with agencies before they've even had a chance to act. And this led to the famous two-part Abbott Labs test. It's actually pretty logical. First, the court asks, are the issues fit for us to decide right now? Basically, is this a clean legal question or is it a messy hypothetical situation? And second, they look at the hardship to the parties. In other words, what's the real-world cost if we make these people wait? And the Abbott Labs case itself is the perfect example of hardship. See, the FDA made a new rule that meant drug companies had to change all their labels and marketing. This wasn't some future problem, it was an immediate hit to their business. They had to choose between spending a ton of money right away or breaking the law and waiting to get sued. The Supreme Court saw that forcing them to wait would cause massive, concrete harm. So, bam, the case was ripe. Okay, this is where things get really interesting and a little more complicated. Because it turns out not all ripeness is created equal. There's a big split in the doctrine that's at the heart of the modern debate. So the courts have basically said there are two flavors of ripeness. One comes directly from the Constitution, it's a hard and fast rule. The other is what they call prudential, which is a fancy way of saying it's based on judicial common sense and good judgment. And the difference between them is massive. Think of it like this. Constitutional ripeness is a brick wall. If a case hits that wall, it's over. The court has zero power to hear it, period. Prudential ripeness, though, that's more like yellow caution tape. The court could step over it, but it chooses not to, out of, well, prudence. It's a discretionary call they make to manage their own business. And that's where the fight starts. Because a lot of people argue that this prudential stuff clashes with a federal court's main job, which is its, and I love this phrase, virtually unflagging obligation to hear the cases that come before it. So if a case clears the constitutional bar, the brick wall, critics say a court shouldn't be allowed to just wave it away for prudential reasons. Exactly, and this tension is pushing the whole doctrine to a really interesting place. So where is ripeness headed? Well, we're starting to see some cracks in the old foundation. Just recently, some judges and legal thinkers have started to wonder out loud if that classic two-part test from Abbott Labs still makes sense.
And they asked a really sharp question. Think about it. If you can prove that a dispute is totally concrete and it's definitely going to happen, can a court really turn you away just because you haven't suffered enough hardship yet? It seems a little weird, right?
And here's their wild prediction. Maybe, over time, that second hardship part of the test just sort of melts into the first part. It won't be a separate question anymore, but just one piece of evidence you use to prove that the whole dispute is real and concrete.
So this leaves us with a really big question, doesn't it? As these lines get blurrier, are we going to see federal courts become more willing to step in and solve problems early on? Or are they just going to find new ways to tell people at the courthouse door, sorry, not yet? This is for entertainment and educational purposes only. This is not legal advice.